Good evening. At this time, I will call the monthly meeting of the Board of Adjustments and Appeals, regular meeting for February 26, 2025. Would you please rise with me as we pledge allegiance to the flag? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. May we have roll call to determine a quorum, please?
Chairman Taylor?
Here.
Vice Chairwoman Van Deven?
Here.
Member Beckles?
Here.
Member Green?
Here.
Member Wheelis?
Here. All right, we have a full quorum, 5 tonight, and all of us are regular members. For those of you who've looked over the minutes for the January 29th, 2025 minutes, is there any corrections or additions that need to be added by anyone? Seeing none, may I have a motion, please?
Motion to approve the minutes.
Second.
Motion and a second. All those in favor, say aye.
Aye.
Aye. Very well, thank you. Okay, at this time, I have a little speech to read. This deals with quasi-judicial confirmation procedures. All persons who anticipate speaking on any public hearing item must fill out an oath card to be heard on that agenda item and sign the oath card thereon. These cards are located on the table near the entrance to the council chamber, or they may be obtained from the recording secretary. This meeting will be conducted in accordance with procedures adopted by Resolution number 24-1997. Those speaking in favor of a request will be heard first. Those that oppose will be heard second, and those who wish to make a public comment on the item may speak third. The applicant may make a brief rebuttal if necessary. A representative for either side, for or against, may cross-examine a witness. Anyone who speaks is considered a witness. If you have photographs, sketches, or documents that you would desire for the commission to consider, they must be submitted as evidence and will be retained by the city. Please submit such exhibits to the recording secretary. And I'll make one little talk. I forgot to do this. If you have a cell phone, either select silent or select off. Would be greatly appreciated. Thank you. All right. We have nothing for the consent agenda, so we will go to old business first. And this is an appeal for number 1-2024, Apollo Gardens Site Development Permit. And we have 3 different means to talk about. If it was the counselor, the first item is Apollo Gardens has made an application to be part of this process. Is that correct?
Yes, on page 102 of your agenda packet, you will find correspondence from Apollo Gardens representative Eric Page. And in that correspondence, the board has been requested to make a motion to intervene as a party. And I believe that the representative of Apollo Gardens is here to speak on this request, to verbally as well as formally in writing make that request that they be added as a party, to an interested party to this proceeding.
Very well. Does everyone on the board here understand what the request is?
Yes.
Okay. So at this time, I'll invite the representatives from Apollo Garden to come up and state why they would request to be named in this project.
Thank you and good evening. My name's Eric Page. I did sign a card. By doing so, I'm under oath. I'm with Schutz and Bowen law firm. Yep.
Please.
Yep. 4301 West Boy Scout Boulevard, Tampa, Florida, 33607, Suite 300. Also, just to put this out there at this point in time, Stephanie Berman is with me. She is a representative, a non-legal representative of Apollo Gardens. She did not sign a card. Our intent is not that she speak. We think these are legal issues, not factual issues, but I wanted to let the board know if you have any factual questions that you'd rather hear from her than me, or whatever the case, she's happy to come up and address the board. Per City of Titusville Resolution number 24-1997, an interested party is defined as a person or a legal entity, and I quote, whose interest may be adversely affected by a board's action. And in this case, what the appellant is asking this board to do is basically revoke this permit that my client has, a site development permit that's issued to them to commence on-site construction of the Apollo Gardens apartments. Mr. Brad Parrish, who's the city's community development director, has submitted a memo that's in the record that advises the board that the 3 provisions in the comp plan that are cited by the appellant are either not applicable or that the permit is consistent with those. We believe that's all correct, but we are asking to intervene in the event that the board does not find consistently with Mr. Parrish's recommendation. If that's the case, then this board would be reversing the grant of the permits to my client, and that would be taking away what is currently an entitlement of my client to commence that on-site construction. And I'm not reading from the motion, and there's more that I could say, but I'll sum it up by saying sections 2.6 and 6.2 of the city's resolution also, I believe, requires acknowledgement of my client as an interested party to have a full and fair quasi-judicial proceeding tonight, and for those reasons and the others expressed in the motion, we'd ask that the board grant the motion to intervene and designate my client, Apollo Gardens, as a party in this proceeding. Happy to answer any questions.
Thank you, sir. Are there any questions of this witness? You understand what he's asking? Okay, thank you, sir.
Thank you.
Do we have anyone that wishes to speak in opposition to this petition to be for that Apollo Gardens be part of this procedure?
Yes, sir.
Yes, ma'am. State your name and address for the record,
Vicki
please.
Conklin, 2920 Royal Oak Drive in Titusville, and I am the appellant. I'm not necessarily objecting to that, but I want to call out a few things.
Excuse me, this is, right now, this is
Yes.
the only thing we're voting on.
That's what I'm
Do
saying.
we,
I
do we
understand.
allow them to be on as an applicant in this? Yes or no? Are you against it?
We'll allow that, sure.
Okay.
But I do
Is-
have some things to say about that. I could say later, I suppose?
Yes,
Okay, thank you,
please.
Mr. Chairman.
Is there anyone else that wishes to speak on this particular matter only? All right, seeing none, we'll bring it back to the board for a motion.
I move to allow Apollo Gardens to be the interested party.
I second it.
Okay, we have a motion and a second to allow Apollo Gardens to be an interested party in this. May we have roll call, please?
Member Beckles?
Yes.
Member Green?
Yes.
Member Wheelis?
Yes.
Chairman Taylor? Yes. Vice Chairwoman Van Deven?
Yes.
So the motion passes. Apollo Gardens is part of the group. Motion to adjourn. All right, we have a second item here. I don't see my number 2. I'm sorry. What is the second part, Counselor?
The second request that was made by Apollo Gardens in their letter to you all is
Yes.
the request for a motion to dismiss based on jurisdiction. And again, I would request that the representative address this motion.
Okay, so we've had a second part to this, that they are, Apollo Gardens wishes to address their part or stating questions about it. So again, sir, you're back up again, please.
Thank you. And again, for the record, Eric Page, 4301 Boy Scout Boulevard, Tampa, Florida, 33607, attorney from Schutz and Bowen, representing Apollo Gardens. This issue came to light, as I haven't been before this board or in the city of Titusville before, honestly. And every city and county has different code provisions and such that dictates what a board does, et cetera. And certainly the city itself has the authority to consider an appeal of this nature. Appellant has raised 3 and only 3 issues, and they all arise out of the comprehensive plan. And per the city code at 31-51, under the powers and duties heading regarding this board's powers and duties, it says the Board of Adjustments and Appeals shall have the power to hear and decide appeals of any decision, order, requirement, or any interpretation of administrative official of these land development regulations. And then it goes on to say including but not limited to the following. But it specifically says that the powers and duties concern the land development regulations. And we've provided that ordinance and case law, and on this issue, the letter that's in the record at 102 through 104, and the case law and the ordinance that's in the record at 128 through 157 is what I'm addressing here. There's a case in there that goes by the name of Kellerman, and on page 41 of that case, it is stated, and this is all good law in Florida, local ordinances are looked at under the same rules of interpretation as state statutes. The next case is the Headley case, and this is at page 9 of that case. One of those rules of interpretation is that if plain language of a statute or an ordinance directs how something should be done, then it acts as a prohibition against it being done another way. So here, what your ordinance says is that this board shall have authority to hear appeals over land development regulations. The comp plan is not within your land development regulations. City Council could have included that authority. It absolutely could have in your city resolution to this board to hear appeals that are based on comp plan amendment issues. That is not what it did. It simply did not do that, and that authority is not with this board. Per the Machado case, and this is at page 631 of the case, not of the record, just to be clear on that, there's a significant distinction between a comp plan and land development regulations, and I strongly suspect you all know that, but for the record, I'll state what it is. A comp plan, which is the 3 issues that are raised by the appellant, is considered the constitution of land use planning within a jurisdiction, and then land development regulations are how that constitution gets applied. So we don't have anything here challenging anything in the land development regulations. The only grounds for the appeal are the 3 provisions of the comprehensive plan. Therefore, we believe as a matter of law and as a matter of statutory construction, as a matter of the plain language that's in your city ordinance, that respectfully this board doesn't have jurisdiction to hear this appeal. And this happens, in lawsuits all the time where the property isn't in the county where the lawsuit's brought, or no one resides in the state where the lawsuit's brought, things like that. And jurisdiction is based on those factors. And here, appellant has simply not raised anything that would allow this board to exercise jurisdiction over the appeal. Happy to answer any questions again.
Does anyone have a question of this?
I have a question.
Yes.
To
Go
City
ahead.
Council. Do you have an answer for that or clarification?
Yeah, the council will come back and respond for the city's stance on this. Thank you, sir.
Thank you.
You may be seated.
As was previously stated, the code does allow appeals regarding these land development regulations. That's what the code specifically states. However, in section 34-9, the administrative approvals required section, that code section requires the administrator, Brad, to make a determination of consistency with the comprehensive plan prior to the issuance of any permit in that one section, as well as others, such as 27-12. The relationship to the comprehensive plan, these land development regulation sections do incorporate the comprehensive plan. And I will also add to that this appeal is based upon the administrator's issuance of his permit subject to his analysis of the submittal and its consistency with the comprehensive plan. And furthermore, this board has previously exercised its jurisdiction to hear appeals of consistency with the comprehensive plan although according to my research, the most recent one was an appeal in the year 2000. So it's not a frequent subject matter, but it has happened before the BAA in the past. And it would be appropriate at this time to dispose of the question with a motion to dismiss or a motion to continue the proceeding pursuant to the request.
Okay, does everyone understand we're voting? We would be asked to vote whether we consider this appropriate, which would be to deny what he's requesting. Is that correct? So we're saying no. If we deny, we're saying yes. If we say the city's position is to continue with this. Is there anyone that wishes to speak on this subject only? Yes, ma'am.
Yes, sir. Our appeal is to the city, and that is against the access of the local road. And LDRs were not really part of what this discussion was to be. If Mr. Page wants to make it about that, we are prepared to address that if you would like us to. But our appeal is based on the comprehensive plan, and as Ms. Farrell accurately said, Section 2712 of the city's code states, in the event of a conflict between these regulations and the comprehensive plan shall prevail. So the comp plan is in the LDRs, and the board does have jurisdiction.
Thank you, ma'am. Is there anyone else that wishes to speak to this particular subject? And I apologize, earlier I did not make this distinction on these first couple of things. Our vote is 3 to 5 on this. It only takes 3 affirmatives or 3 denials, unlike our regular full hearing, which it takes a vote of 4. So that everybody up here understands that. Yes. Okay, good. All right. Do I have a motion to accept or deny this request from Apollo Gardens?
I move to deny the request and proceed with the proceeding.
Do I have a second?
Second.
Okay. Roll call, please. And so you will say deny or accept, okay, in your answers.
I thought it was yes or no.
Well, I changed it since he said he used the word.
Okay. Member Wheelis,
Deny?
Chairman Taylor,
Deny.
Vice Chairwoman Van Deven,
Deny.
Member Beckles,
Deny.
Member Green.
Deny.
Okay, so the second part of this goes through, we have decided that the board does have authority to speak on this subject. Now, there is a third phase of this, which brings in applicant lacking or having standing to be in this procedure. So as an independent or dismissal, we have to go applicant standing, and that would be the applicant, which would be Ms. Vicki Conklin. Is that correct? Okay, Counselor, would you give us status on that, please?
Yes. As provided in my memo to the board, it's on page 88 of your agenda packet. Pursuant to the Titusville Code, Section 34-249, any affected property owner or his agent may file an appeal. Accordingly, the first issue to be addressed by the Board of Adjustment and Appeals will be whether the appellant is an affected property owner with the standing to appeal the issuance of a site development permit. You can't hear me? If the board finds that the appellant has established standing as an affected property owner to present this appeal, the board will proceed to hear the merits of the appeal and render a decision. Are there any other questions on this?
Did I understand you by saying whether they're a property owner or an agent?
The Titusville Code says any affected property owner or his agent
His agent.
may file an appeal.
Okay. Thank you.
Okay, so we have a motion to declare whether the applicant, which is Ms. Conklin, has proper standing in this procedure. Do you wish to address the board on this, ma'am?
Thank you, Mr. Chairman. Again, my name is Vicki Conklin. We do believe that we have standing, and for several reasons. I want to thank the Board of Adjustment and Appeals for meeting tonight and dedicating your time. These are serious issues for the future of our city, and I appreciate what you're doing. I also would like to recognize the residents here that have come to join us tonight. And if I might just ask them to stand, because they know that I'm representing them, and we have some other documents to
I'm
provide
sorry,
for
this
you.
is about you, ma'am.
Yes, sir.
Not the audience or other
Okay.
people. This
Okay,
is
that's
about
fine.
your standing,
Okay.
ma'am, only.
All right. So Section 34, 249 of the Land Development Regs permits appeals from an administrative official decision to be filed by any affected property owner or his agent within 30 days of the decision. We did file that timely. There is no provision in the city code defining affected property or saying how far, how near. There is no definition in that anywhere in the statutes that we can find. On November 11th, 2024, a site permit was issued for Apollo Gardens authorizing on-site construction. On December 5th, I, Vicki Conklin, filed an appeal to the approval and issuance of the site development permit. I am a citizen, I'm a taxpayer, and I'm a voter living in Titusville, and I'm a resident living in the Royal Oak subdivision, which Mr. Johnson is handing to you. The subdivision lies adjacent to the site development permit of Apollo Gardens, so I'm preparing some exhibits for you. In addition, I am an authorized agent of Royal Oak Neighbors, RON, Royal Oak Neighbors, LLC. The Royal Oak Neighbors, LLC purpose is, together as homeowners, to preserve our neighborhood and working together to
Ms. Conklin,
protect
the
our community.
LLC was not presented in the paperwork
It
to
is, sir.
us.
It is. Mr. Johnson has that to hand to you. Mr. Johnson is distributing that to you as proof of the LLC.
Please hold.
Okay?
Well, I'm not saying it doesn't exist.
Uh-huh.
I'm just saying the application
Mm-hmm.
does not have that information on it.
That is correct, but I'm offering you the reasons why I do have standing. And that is that Royal Oak Neighbors is adjacent, and I live in Royal Oak Neighbors, and our organization is part of what helps to help this community.
Was there a reason they were not mentioned in the original application that you presented the city?
I filed it under my name alone, thinking it was better to do that than Royal Oak Neighbors LLC. Thought it seemed more clear that it come from one specific agent, and so that's me. I'm saying I have standing because I live in Royal Oak, but also I represent Royal Oak Neighbors, which is in the adjacent property. So that's what I'm saying. Also, the property owners of Demerit, Ternassa Drive, and Spanish Oaks condos are members of our Royal Oak Neighbors group.
Yes,
And I've been
ma'am. We
authorized.
understand that part.
I've been authorized by the owners of the property adjacent to the site permit to represent them in this manner. And we do have the originals, we have the Spanish Oaks, the board president, the HOA president signed that.
Yes,
So
ma'am.
those are being
But
submitted.
their name is not on the application, and we're not considering that right now, ma'am.
Okay.
Please stick to, you have stated your reasons.
Mm-hmm.
Do you have any more? I know neighbors live around them, yes.
Mm-hmm. Okay.
But I don't need to hear that right now.
Okay.
Do you have any more to add why you should
Well, upon
remain?
signing the notice of appeal, I signed in my capacity individually and as an authorized member. So if you didn't see that, I'm sorry. And yes, the LLC papers were not submitted with that, but I'm providing that information to you all. I believe the approval of the site plan is contrary to the City of Titusville Comprehensive Plan. The plan affects me as a property owner and the residents of the Royal Oak subdivision. It will harm our property values, create traffic jams and problems on the local streets, create flooding and other issues. I am entitled to have standing. There's nothing in the statutes that says how far away you must live. And I know that Mr. Page has measured how far, that I'm 0.8 miles, but I am within that community and firmly believe that I have standing.
Thank you. Yes, sir. Your point. You don't have to go through the whole thing.
Thank
Your
you.
name, sir.
We did submit, it's discussed in the letter that's in the record at page 102 through 104, and it's discussed in two maps that we pulled off the internet, and we provided the information that under Florida law would allow a judge to take judicial notice of those maps. So we believe that that's valid evidence. That's at pages 158 through 162 of your record. We do believe that there's an issue here with Ms. Conklin standing. The crow flies distance for her from my client's property to the property that she owns is 0.29 miles. That's 1,535 feet. The shortest driving distance is 0.8 miles. There are multiple golf course holes between my client's property and the appellant's property. And I don't believe what you've heard from Ms. Conklin provides any evidence to you in this quasi-judicial proceeding where you could find standing. I think what it does do is put you in a position where if Ms. Conklin has standing here, then anyone who lives that far from a site would have appellate standing. An adversely affected property owner has to mean something. It's not just a property owner. It's not supposed to be everyone in the city limits. There has to be an adverse effect. And there's been no statement of an adverse effect that's based on evidence to you. There's been talks of flooding. There's been talks of traffic. Those aren't issues that are raised in this appeal. And those aren't issues that can support standing in this case because it's not evidence. It's merely speculation. What would happen here is if Ms. Conklin has standing, then anybody can come before this board as an appellant and have standing if they live as far away as she does and have no other adverse effects to their property. And I believe that's, as I stated in the letter, I believe that's a Pandora's box. You're going to open this up to whoever wants to come in and put in an application for appeal that lives within that distance of any property. And don't believe that's appropriate under Florida law because there's got to be some adverse effect that's shown to her property rights, and that doesn't exist here. Any questions? Thank you.
May I speak?
Conklin?
I believe that Titusville is a community of residents. I'm a resident, and that entitles me. Mr. Page does not even live here. I live here. We all care. But the second issue, just a minor point perhaps, but you can tell he doesn't live here. He wants to talk about golf holes between my house and that property. Does he know that the golf course closed down in 2012? I don't think there's any holes left.
Just a moment, ma'am. I haven't called for witnesses yet. At this time, we will open it up to anyone that wish to address this item only. Remember, you are addressing this item only. This is not the merits of the case or future discussion. This is only whether Ms. Conklin has standing and that, as she says, damages will be done to her with this being built. So you'll need to give your name and address for the record. Yes, ma'am.
I am Rachel Tucker. My address is 3140 Demerit Drive. I live within a sprint run from the property in question, and I wish the board to consider Vicki Conklin my agent for whatever it's worth to you for this vote. Thank you.
Do I have anyone else? Yes, ma'am.
Good evening, board. My name is Megan Moscoso, 3031 Demerit Drive. I live within 500 feet of this development, and I would like to grant Vicki Conklin as the agent. Thank you.
Would like to address this item.
I'm Elizabeth Parker. I live at 3446 Trevino Circle, and while I am a block away, my house backs up to the main road that would be accessing this development with the added traffic, as well as the likely emergency services calls that will be coming all times of the day and night and invading the quiet of my property and my home. I would like to let Vicki be my agent as well.
Thank you. Yes, sir.
Good evening. My name's Gerard Phillips. I live at 1755 Harrison Street, which is the community just north of the proposed development, and I would like Vicki Conklin to be my representative.
Thank you. Do I have anyone else who wishes to speak to this matter?
It's my understanding you're going to be putting a complex in between Demerit Drive and Barna, correct?
Sir, you are speaking. You need your name and your
Oh,
address
my
for the
name's-
record.
My name's John Hoffmeister. I live at 2820 Demerit Drive. I've been living there since 1999, so I'm very familiar with the property.
All right, sir. We will have discussions about the property later, but right now we're deciding whether or not Ms. Conklin is to be, does she have standing to be represented and speak on this matter of the appeal that she has made?
My name's John Littrus. I live at 2785 Mangrum Place, and I'm right on the golf course on the 9th hole, and I wish Ms. Conklin also speaks for me.
Thank you.
My name is Joan Fischetti. I live at 2780 Demerit Drive. This property will be directly in front of me, right across the street. And I would like to have Vicki be in charge of debating this for me. Thank you.
William Ballant, 2756 Demerit, will be directly affected by this project. I would like Vicki Conklin to act as my agent and advocate. She's put in a ton of work and a lot of energy on this project.
Thank you, sir.
My name is Beverly Searle. I live at 2742 Demerit Drive. I am also directly across the road from where this project is, and I would like Vicki Conklin to be my agent in this procedure to give her standing.
Thank you.
Hello. Jacqueline Outlaw. I live at 2550 Demerit Drive. I'm directly across from where I will be affected, and I want Vicki to also be my agent.
Thank you.
My name is Juan Quinones, 1608 Tornisa Drive. This property is going to be closer than the distance from me to you guys right now. So definitely, I want Vicki to be my representative and my agent on this matter. Thank you.
Thank you.
My name is Penny Riley. I've lived at 3129 Demerit Drive since 1967. And I also want Vicki to be my agent.
My name is Janet Davis. I live at 1614 Ternessa Drive, which is at the corner of Demerit and Ternessa. I am the closest house to the proposed project, and I authorize Vicki Conklin to represent me in these proceedings.
Thank you.
Hello. My name is Eileen Adams. I live at 2790 Demerit Drive. I'm right across from where this proposed development is. I would like for Vicki Conklin to be my representative in these proceedings.
Thank you.
Hello, my name is Michael Dwyer. I live at 2852 Demerit. I'm going to be right across the street from this project, and I would like Vicki to be the representative for me for this hearing.
Thank you.
Good evening. My name is Arliss Nobles. I live at 2864 Demerit Drive, right in front of where it's going to be, where the proposed development is going to be. And I would like Vicki Conklin to represent me in this endeavor. Thank you.
Thank you.
Hello, my name is Thomas Polk. I'm at 1705 Harrison Street, and this property is right behind me. And I also ask Vicky to represent me.
Thank you.
I'm Reba Reese. I live at 1426 Tanessa Drive, and this building would be practically my backyard, literally. I'm against it.
But are you wanting Ms. Conklin to represent you or not, ma'am? Would you come back to the microphone, please? As everyone else expressed, are you wishing Ms. Conklin to be your representative?
Yes.
Thank you.
Good evening. My name's Donna Horn, and I live at 1508 Ternesa Drive, and I wish Vicki to be my representative also. Did you hear me? Thank you.
Thank you.
Good evening. My name is Robert Tucker. I live at 3140 Demerit Drive. I would like Vicki Conklin to represent me as an agent in this matter.
Thank you.
My name's Mary Schwager. I live at 2570 Demerit Drive, and I would like for Vicki to be my agent in this matter.
Thank you.
My name is Sue Ann Smith, and I live at 2552 Demerit Drive. And there's been a lot of strange things happen there. I have had to call the police before.
Yes, ma'am. We'll discuss that later. Right now, are you for or against Ms. Conklin?
I want to say no.
You don't want Ms. Conklin to represent you?
I don't know. I mean, I've lived there only 4 years.
The question is, ma'am, do you want Ms. Conklin to represent you in
Yes,
this
ma'am.
procedure?
Yes, sir.
All right, so you won't, you're not opposed, you're for.
Sorry.
All right. Thank you.
My name's Susan Dam, and I would like Vicki Conklin to represent me. I live at 1775 Harrison Street.
Thank you.
Hello, my name is Robert Delgado. I live at 2762 Demerit Drive, and I do authorize Vicki to be our agent.
Thank you.
Hello, Maurice Turini, 2604 Demerit Drive. I want Ms. Conklin to represent me.
Thank you.
My name is Ann Ward. I live at 1685 Harrison Street, and I want Vicki Conklin to represent me in this proceedings.
Thank you.
Yes, hello, I am Scott Root. I am at 2746 Demerit Drive. Our condo is currently on the market, and given the comments that we are getting from the very few people that have looked at it, that I would like Vicki Conklin to represent me.
Thank you.
Hi, Brian Fielder from 2816 Demerit Drive, and I want Vicki to represent us.
Thank you.
Good evening. My name is Claudia Quintero. I own 5 units over at Village Square on Harrison Street, and I would like Vicki Conklin to represent me.
Thank you.
My name is Cinnamon Baldwin. I live at 1725 Harrison Street, Unit 121 at Village Square, and I'd like Vicki to represent me also.
Thank you.
My name is Marilyn Landsman. I live at 1999 Harrison Street, and I would like Vicki Conklin to be my representative.
Thank you.
My name is Gloria Brown, 1515 Tunisa Drive. I would like Ms. Conklin to represent me.
Thank you.
My name is Richard Bartek. I live at 1602 Ternessa Drive, and my back lot line's within 60 feet of this project. And I do want Ms. Conklin to represent me.
Thank you. Just a moment, sir. Counselor, now that we've had all these people add themselves as part of a group, does that change the diameter or parameter of the request?
The application that you received was submitted by Vicki Conklin. You've received that information, and it is up to the board to decide if she has standing based on the evidence that's presented to you at this hearing. I can't tell you how to vote. But you just have to listen to what you've heard and make a determination.
Very well. All right, sir. Yes, sir, you may rebut.
Eric Page, on behalf of Apollo Gardens. The memo from Attorney Farrell directed this board to Titusville Code Section 34-249, and I'm going to read that. It's just a couple lines. Appeals from a decision of an administrative official shall be filed on forms provided by the city unless otherwise provided for herein. Any affected property owner or his agent may file an appeal. The question on standing is based upon the capacity of the person that filed the appeal. It was filed in an individual capacity at the time it was filed. None of these good folks conferred upon her agency authority. The question is whether Ms. Conklin individually at the time the appeal was filed has standing. Thank you. Any questions? Sorry. Thank you.
Ms. Conklin, could you come back to I have a question for you, please.
Yes, sir.
All right, we have all the maps, all that was done before. We
Yes.
understand the distance and all that. You're saying this is going to damage your property. How is this going to damage your property? I've not heard you say that what damage that this complex would have for your property, ma'am.
Mm-hmm. It's multifaceted. It's an issue of traffic. It's an issue of emergency services. It's an issue.
This is for your property, though, where you live.
Yes, within this Royal Oak community where we all live and where I live. Yes, sir. Absolutely.
Do we have any other questions from up here for Ms. Conklin while she's standing?
Yes, sir.
I have one question.
Yes, ma'am.
I noticed that when you filed as an individual.
Yes, ma'am.
Property owner. Then later on in the filings, you updated it to read, well, I guess it was from Mr. Brooks, the attorney.
Mm-hmm.
And he says, on behalf of my client group, Royal Oak Neighbors LLC, Vicki Conklin, agent.
Mm-hmm.
It's kind of like it changed midway.
Well, I'm still the same person. It was just offering you more validation that indeed I do have standing because I do represent our community as a whole. I represent me. I represent our Royal Oak neighbors. I represent the folks on because we're all Royal Oak. So it really wasn't a change. I respect what you're saying, but it was more of a validation and giving you more information perhaps to let you know that it's not just Lil O me on Royal Oak Drive, that it's really all of us. But I understand what you're saying. I did file under my name. Mm-hmm. Thank you. Any other questions, Mr. Chairman?
I have none. Thank you.
Okay, thanks.
Okay, so the question before us is, does Ms. Conklin, as the applicant, have standing to go forward with this appeal? Do I have any comments or questions for either staff or for council or anyone else?
Mr. Chairman, in researching the definition of affected and how it applies to our codes, we look in Black's Legal Dictionary and we can. Go closer to your mic, sorry. Thank you. In researching the definition of affected, to produce or influence upon or an alteration in something that affects a person, has any effect on them. in looking at Black's definition in Black's Legal Dictionary in 5th edition, it indicates in the commentary that they're looking for a special injury to a special interest that exceeds in degree the general interest in the community good shared by the general public. So we're looking for something that affects this group, or Ms. Conklin specifically, that is different than how it might affect someone living in another portion of the city who may travel the same roads, who may use the same businesses, but how is it different? That's what we're looking for as affected.
Thank you, sir. Is there any other questions the board members would have, again, with any clarification?
Chelsea, I would like clarification. Just like Eric said, when she applied, she was applying as an individual. Her name was the only one on the application. So does that have any bearing on this?
The application for the appeal was submitted by Vicki Conklin as an individual.
That's all you're going to tell me?
I'm not sure how I can further elaborate on that for you. Was there a question?
Well, I mean, so does she even have standing to represent these people, even though they said it tonight, but when we're dealing with the application, and when the application was filed, it was not filed as a representative of anyone other than herself.
I believe that's correct, that the application you received did not indicate the agency that you're hearing tonight.
Okay. So does everyone understand what we're looking at tonight as far as standing on this part of the three motions we've gone through so far?
Just one comment.
Yes.
However, on the application. Oh, yeah, I do. On the application, she's stating reasons why she's an affected party negatively, the negative. And she is a resident of Royal Oak, and that's how she described herself. That's just an observation of looking at that appeal application.
Thank you. Any other? I'm sorry, the public hearing is closed at this time. Any other questions for the board on this question? Then I will take a motion to either approve or deny Ms. Conklin as an affected, that has standing being affected by this project.
Motion to approve applicant's statement of standing in this case.
All right, we have a motion to approve. Is there
I second it.
okay, we have a motion and a second. May we have roll call, please?
Chairman Taylor,
No.
Vice Chairman Van Dieven,
Yes.
Member Beckles,
No.
Member Green,
Yes.
Member Wheelis.
No.
Okay. So the motion has failed, and we've determined at this point that Ms. Conklin does not have standing in this procedure. And this closes the, this discloses it. Excuse me, this public hearing is not open right now. We are through with this matter. It was denied. This is denied. No, ma'am, I'm sorry. With this vote, that ends this procedure. We're not going forward.
And you've already decided it, so there is no appeal.
You didn't give her a chance to elaborate on how her property is being affected, and all of our property is being affected. You did not give a fair hearing.
Sir, this is not open for open discussion back and forth. Now the matter has been closed. So we're done with this. Whether you choose to stay here or not, we're going to take a 10-minute recess at this time.
You're not allowing a whole community to speak on a technicality. You said at the beginning that property owners can have an agent. She's our agent. Does it say on the form she filled out that she has an
Well, at least we have protection here.
Meeting, please come to order. Meeting, please come to order. Okay, the next part on the agenda is petitions and requests from the public that wishes to come up and speak. Everyone that wishes to come up and speak will be asked to give their name and address for the record, and then you will have 3 minutes. This will be timed, and at the end of the 3 minutes, should you choose not to continue with, if you should continue on with the conversation, the microphone will be turned off. So please be aware of that. And so at this time, we'll open it up and we'll have the first person to speak. And please understand, these are comments from you to us. It does not mean that we answer or talk back or give you a response, because we're not prepared for that. Okay? First up.
Hi, Megan Moscoso, 3031 Demerit Drive.
Thank you.
Mr. Taylor, I have to say, I'm very disappointed if this is how you treat our residents. As a city council member, I am completely embarrassed, because these are residents who have concerns and who have questions, and the way you are treating them is absolutely unacceptable. There's a way to conduct business, but threatening, not speaking to anyone is not how you do it. Thank you.
Dr. Kathleen O'Rourke, Titusville resident. I'm reading 3525 Palmer Drive.
Thank you.
I am reading a letter from our County Commissioner, Katie Delaney, and she said, "Dear members of the Titusville Board of Appeals and Adjustments, I am writing to express my deep concern regarding the site development permit issued for the proposed Apollo Garden project at 2727 Demerit Drive. As you are aware, the city's comprehensive plan explicitly prohibits multifamily developments from being accessed via local residential roads. Allowing Demerit Drive, a 22-foot wide residential street, to serve as the primary access road for this development directly violates that plan. Demerit Drive is simply not designed to handle the increased traffic volume from construction equipment, emergency vehicles, or the daily needs of multifamily housing complex. Residents have already observed the challenges on this road, such as trash collection vehicles struggling to navigate through. This raises significant safety and quality of life concerns from nearby neighborhoods, including Spanish Oaks, condos, Village Square condos, and homes on Demerit and Tunisa Drive. The city's decision to issue a permit without aligning it with a comprehensive plan undermines trust in our local government and sets a dangerous precedent. Therefore, I urge the Board of Adjustments and Appeals to rescind the site development permit for Apollo Gardens and require the developer to propose an alternative access route compliant with the city's legal requirements. Thank you for your attention to this matter, and I trust you will make a decision in the best interest of the residents and the integrity of the Titusville planning process. Sincerely, Katie Delaney, Brevard County County Commissioner.
Thank you.
Vicki Conklin, 2920 Royal Oak Drive. I would like to call to attention that when I did file this application, it's a signature of appellant. Nowhere did it say agent, signature of appellant, and that's how I filed. The second thing I want to bring to mind is this request to intervene. This was submitted to the city by Mr. Page on the 28th of January. Our Board of Adjustment meeting was on the 29th of January. I was not notified of this until the updated agenda was issued on the 20th of February, allowing 5 days notice to me that he has requested to intervene. I don't think that's due process, and I don't think that's a fair way that anybody else gets treated in this city. The third thing, is this the way that the rules and the regulations of Titusville are supposed to work? We have been petitioning this city for 2 years, 22 months about this project, and we've been asking about that road access violating the comprehensive plan. This has been our only way to be able to come forward with this appeal in a formal way. We paid $625 to come to you because the city is not listening to us, and they're violating their comprehensive plan. So we were told this is the only way to do it. It's unusual. We didn't want to change zoning. We didn't want to change LDRs. We're not wanting to change anything. We're just asking the city, please obey your comprehensive plan. The final thing is, I received a letter from Carrefour Apollo Gardens attorney in January, and this was from Mr. Cunningham, and we have copies of that. Okay, so you have a copy of that. It was intimidation. I will tell you up front, it was intimidation. I will read part of page 2. It says, you are strongly urged to immediately cease any further actions or statements, withdraw any baseless appeals or objections targeting this development. Should you fail to comply, Apollo Gardens is prepared to take legal action, including filing a lawsuit under the FHA for denial of housing, interference with housing rights, and discriminatory statements. That doesn't seem right that they send that to me in January already, before we even tried to meet in January, telling me that they're going to sue me because we are representing our rights as citizens of Titusville. Something is really wrong with this process if our residents can't be heard by our board. Thank you.
Elizabeth Parker, 3446 Tremino Circle. Again, further to Vicky's comment, I don't know whether she made it clear, but your application does not request whether she is an agent or not, meaning she didn't have the option on her application to sign as agent. It only left room for her name. But further to our concerns, this 84-unit development, Apollo Gardens at the end of Demerit, has critical flaws in its traffic impact analysis and should never have gone this far. It's in violation of our land development regulations as well as our comprehensive plan because they do work fist and glove. And there are significant infrastructure concerns tied to this site and the proposal. And to Vicky's point about the letter, this is not about equal housing rights, because if it were, the city's Section 8 candidates and the disabled in our community would be allowed to apply for a unit in this apartment, but we are not. It's being reserved for people they're collecting off the streets in Orange and Brevard counties who are recidivists and addicts, and it will not ask for them to have background checks, nor will they be supervised, meaning we don't even know who these neighbors will be in our backyard with our children out playing in the streets. The expected EMS calls will be over 400, and this street cannot even support a trash truck on trash day because cars parked on the street make the street too narrow to navigate. If you look at our transportation element policy 1.1.1 and objective 1.92, our road capacity must be appropriate. Dumping this out on a local road is inappropriate, and the traffic study they supplied say it's dumping out onto Barna, which it is not. They also cite Pine Doe, which is miles away. The traffic study is flawed and inappropriate, and it was passed anyway. This should not go forward. It's a danger to the safety of our community, and it is also in violation of our health, safety, and welfare, B1 and B2. Finally, our property values will be impacted by this, and we will not be able to sell our homes for for the full value should we decide to leave the community, because nobody is going to want to live near this community that they are developing. Finally, it is not harmonious with the residential neighborhood they are plopping it into, and it's at the end of a dead-end road. There will be noise. There will be people wandering through our communities and our yards. It endangers our welfare and the infrastructure, and it ignores infrastructure limits, and it's arbitrary and it's actionable. We are not opposing a multifamily unit dwelling. What we are opposing is essentially not even a supervised unit. Thank you.
Thank you.
Hi, everybody. My name is Katie Delaney. I'm the county commissioner that represents District 1. And I read, luckily,
May I have your address for the record, please?
Sure. 5105 Cabbage Palm Street. My letter was read, thankfully. I wasn't sure if I was going to be able to make it tonight, and that's why I prepared a letter. But I just have to expand on that because I am truly horrified. The fact that the residents of District 1 of this community showed up now twice to speak on this, and this board decided that this was within your power to change this. These are your neighbors here. These are your neighbors. And you all decided that you were going to shut their mouths tonight and not let them proceed. That's unacceptable. The people of this community should be making this decision. I have to mimic what Councilmember Moscoso said. So, thank you.
Thank you.
Juan Quinones, 1608 Tonita Drive. You didn't give us a chance whatsoever. It's embarrassing. We had a lot to explain. As a community, we prepared a lot for this time. We came over almost a month ago. We are here again, and you shut us down. I'm a veteran of 25 years in the military. So with all due respect, sir, it's embarrassing. Well, these people are talking over here. You're eating. Okay? That's all the respect that you have for these people. That's all I have to say.
William Ballant, 2756 Demerit. Somehow, I don't feel like we had a fair hearing. I mean, wow. All these people are here tonight with a concern, and you're not willing to listen to it. I heard some good points being made, but I guess it's just like talking in the air because this isn't really an appeal right now, right? The appeal has already been stopped before it was started. On a technicality, you did not listen to the merits of the case that all these good people have put their time and energy and concerns into. You didn't listen to us. You're getting out on a technicality, or trying to. I would ask that we have a fair hearing, and I would like to see you folks again, and I'd like to have us have a chance to state our case, because you didn't give that to us.
Rachel Tucker, 3140 Demerit. First of all, thank you to the two of you who voted yes. I very much appreciate it, and my words are only for the three of you who voted no. So since the three of you are only interested in technicalities and not your fellow citizens of Titusville, I will speak in your language. And in your language, it is a technicality that you must listen to us at this meeting before you make your decision and before you cast your vote. That is the purpose of why we are here this evening, is that you are to consider what your fellow Titusville citizens said. We all, one by one, stood up here and told you what we felt was accurate and what we felt like should be considered for this application. Vicki did update the application to say that she represented this group, and we walked up here and we said to please consider this. This is a technicality. It is technically part of what you are supposed to consider, is our voice. That's what this meeting is for. That's the purpose of us having this meeting here tonight. If you want to disregard that, you disregard something that is part of the process, the due process. And I would like to ask that you guys recall a vote and consider that this time, because you didn't the first time. And if you're not willing to consider that, it just makes all of us wonder why it is that you are more willing to vote no on a technicality than yes on the basis that we're all willing to be here and give up our times, when there are those of us here who are working 60-hour days and we really do not care to be here tonight any more than you do. But this is our home, this is our roof over our head, this is our equity in our home that we've worked decades to have. And if it was yours, I think you'd be pretty darn upset that we were voting on a technicality.
Mark Johnson, 1927 Harrison Street. I was just wondering if Vicky has no standing, then why did Apollo Development decide to threaten her with a lawsuit? Thank you.
My name is Michael Dwyer. I live at 2852 Demerit. I'm right across from this project that's going to be built. I think it's a super bad idea that this project is approved already. And I feel that you guys did not give us a fair chance here tonight and need to reconsider and give us a chance to voice our opinions on this agenda for this. It was shut down too quick and feel it wasn't fair to all these people that came to this hearing tonight. Thank you.
Hi, my name is John Hoffmeister. I live at 2820 Demerit Drive, and I have to respectfully ask the appeals board, have you given the owners around the area, adjacent to the area, the option to buy the land out collectively? And that way, the landowners collectively could decide who builds there or if anybody builds there. That's the only question I have. Okay.
Is there anyone else that wishes to come before? Yes, sir.
Yes, my name is Earl Johnson. I live in 3135 Saunders Place. I want to remind the board of the whole purpose of what we were here for. It was not speaking about this specific project. It was an overarching issue about the comp plan and the fact that the city is not adhering to the comp plan. That puts the city in legal jeopardy. Apparently, I don't know, are you guys not aware of that? They are in legal jeopardy, and there are legal consequences for the city not obeying the comprehensive plan. It's in the Florida statutes. This is part of what we were going to present, but you curtailed our presentation in this by, in my opinion, quite unfairly, telling us we didn't have standing. The hell we don't have standing. We certainly have standing. And this whole thing was the comprehensive plan specifically says you have to have collector or arterial road access for multifamily. This access is on a dead-end local road that's only 22 feet wide. It's absurd. There's no way that that little road can handle this kind of traffic. We would have had, if you had granted standing, as you should have, you would have heard what I'm just telling you right now and substantiated significantly better than I can in 3 minutes. So you really cut yourself short, and you specifically cut us very short for something you had the obligation to hear from us, and you chose not to. I don't know why you did. It seems really absurd to me. How can you look at all of the people that were in here and the cards and the papers that we submitted to Kim, where all these people had signed saying that Vicky was their representative agent? This is not it shouldn't be a mystery here. There is no doubt but what all of these folks here were fully supportive of Ms. Conklin having standing. I mean, this is absurd that you even voted the way. This should have been a unanimous vote that yes, she had standing. And yet for some reason you didn't. It's a real puzzle to me. I mean, I think this is absolutely ludicrous. And I remember the issue is what we were bringing forward was not specifically relating to CAR 4. The issue was about the comprehensive plan and the fact that it's being violated egregiously here by accessing a local road, a dead-end local road, moreover, on top of that. And this is just really grossly unfair to everyone that lives in this particular area for what they're going to have to, their daily lives, what this is going to impact. And I'm at a loss to understand why you didn't even want to listen to the damn argument. It's just a total puzzle to me. Thank you.
Hello, and thank you for letting me talk. My name is Seth Adams. I live at 3525 Nelson Place in the Royal Oak area. And I just want to say I grew up here, went to elementary school here at Coquina, went to Astronaut High School, played football. Titusville's a sleepy community, so far pretty safe. It's a nice place. And this Apollo Garden thing that's coming in that you guys are we're talking about here, this is not a church they're putting here, okay? This is a group of people who, God bless them, but they're drug addicts, recovering people. Some people have been in some trouble. And it's not just them that live at that location. It is also their friends and their family, okay? There's no supervision. There's nothing. So their friends and family can come in through there throughout the night, throughout the day. The other location we understand down in Palm Bay of this same people, they wear the police out because there's so many police calls for trouble. And this is a tiny little area. As far as the traffic, obviously the traffic can't handle it. Demerit Road can't handle any more traffic. The trash, the sewage, that's not even an argument. I mean, that's a done deal. Can't handle it. There should no be reason for anything like that to come here to that spot. Okay, it would be better in another spot, but not this spot. But having said that, this is a dangerous group of people coming into town. This is not a church. And so it is our responsibility, your responsibility if you live here, our responsibility, city council. Some very important people have come up here, by the way. But it's our responsibility to keep that stuff in another location. Put this Apollo Gardens somewhere where it belongs. It doesn't belong in a small area like that, right on top. The residents are already living on top of each other. It will not be able to handle that for a minute. It's going to be trouble. And if we can't stop this, or if this goes ahead, it's kind of like we're responsible, like you're responsible for bringing some trouble into our town that I grew up in. So please, you've got the power. You can do it. You can change the vote. Support Vicky. That was a false technicality. It's not even on the form there. You've got the power. Let's just fix this and go home, and let's put this location and put this thing in another location. We don't need to put it here where friends and family, children are. It's very dangerous for children, very, very dangerous for the children to have these people wandering around with the friends and family coming in and going out throughout the night. God bless them. They are who they are, but it's just very dangerous for our community. Okay, thank you.
William Ballant, 2756 Demerit again. I just wanted to mention to you good folks that this modest fellow, Earl, who stood up just a moment ago, yeah, okay. He was on the very same board that you folks are sitting on for several years. So if he is like mystified on how you're ruling on this thing, this guy has standing because he knows you folks. He's been sitting there. He sat there for years and he's saying, what are you people doing? I mean, not all of you, because some of you were going to give us a chance, but not you, and not you, and not you. What? Defend yourselves. Tell us why. I mean, come on.
Stale Bailey, 6395 West Baker Circle, Cocoa, Florida. I just want to put on the record tonight that I'm looking at the February 26, 2025 agenda, and it looks like it's already recorded that the recommendation from staff is to concur with the administrative interpretation and deny the appeal. And if you look at the agenda, it also under 7 old business, it says deny the appeal. It's interesting. I think it's time we start following the money on some of these board members. Thank you.
Good evening, council members. My name is Pablo Herder, 1894 Orleans Drive, Melbourne, Florida.
I'm a resident of Brevard County, serving as a fair housing attorney with Florida Legal Services. Florida Legal Services is a nonprofit organization that provides legal assistance across 15 counties in Central Florida relating to fair housing. My work focuses on ensuring that individuals and families have equal access to housing opportunities, free from discrimination. On a daily basis, I provide legal assistance to individuals facing housing discrimination, advocate for inclusive housing policies, and work to ensure that the federal and state laws are upheld. The Fair Housing Act, originally enacted in 1968 as part of the Civil Rights Act, is a fundamental piece of civil rights legislation that protects individuals from discrimination in the sale, rental, and financing of housing. It was passed to address systemic barriers that prevented marginalized groups from securing housing and building strong, stable communities. The Act prohibits discrimination based on race, color, religion, sex, national origin, familial status, and disability. Tonight's discussion is particularly relevant to one of these protected classes, people with disabilities. Housing is not just about a roof over one's head. It's about ensuring that all individuals, regardless of ability, have housing that meets their needs. This means that ensuring that the new developments are accessible, inclusive, and compliant with fair housing laws. Decisions that limit housing opportunities for people with disabilities by rejecting inclusive development projects are in counter to the Fair Housing Act. Denying such opportunities on the sole basis of disability is a form of discrimination and a violation of federal law. More importantly, it's a step backward in creating a community that's welcoming to all. I urge this council to approach housing development with fairness, inclusivity, and commitment to ensuring that people with disabilities have equitable access to housing in Titusville. Thank you for your time.
Especially if you're Titusville residents.
Excuse me, please don't respond unless you're standing in front of the mic.
I'm Bev Searle, 2742 Demerit Drive. I wasn't going to come up here. I'm absolutely not a lawyer. But what that lawyer just said to me, we are not discriminating. We are not saying this is the sole reason because there may be drug addicts or some other psychological problem. We have a whole bunch of reasons. We aren't saying, sorry, I will lose my point because I'm so upset with this whole thing. There is a precedent. There is evidence. Palm Bay, someone mentioned. They have 400 or 500 or more police calls, and there's something going on all the time. I'm 76 years old. There's people here with canes and walkers. We live in this area. We're alone, and we get afraid really easy. There was a man camping out by my backyard for 2 years with a machete. The police were there all the time, and it wasn't only me calling. But that poor man was homeless. I think he probably did have some disability, but I didn't want him in my backyard with that machete in his hand. I don't want a place 100 feet across from me when I have to take my garbage out in the evening, or when someone wants to walk their dog and be afraid to walk out of my house because I don't know who's living there. I don't know who's coming there. Maybe the people living there are trying to get better, and that's great. I wish them the best. But we don't know who else is coming there either. I'm sorry, that is not discrimination. That's evidence, that's precedent. And I'm not a lawyer.
I'm Kathleen Flynn. I live at 2805 Player Court in the Royal Oak neighborhood. I'm going to read something about our main precedent here. In 2022, St. Petersburg residents stopped a 225-unit condo project at 400 Central Avenue after proving the TIA understated traffic, 1,200 versus 2,000 trips, dropping LOS below standards. On March 17, 2022, the council denied it for safety and plan inconsistency, a blueprint we will follow. If Apollo Gardens proceeds on this flawed ITA or TIA, we'll challenge it as 1, non-compliant with LDRs, and I have all the sections listed here. Also 2, inconsistent with the comprehensive plan per FS, whole bunch of numbers. Number 3, arbitrary, violating due process. Our demands and intent to litigate. We demand 1, rejection or revision of the TIA to reflect Demerit's true status and impacts. A public hearing to assess this project's special nature under Section 28 to 87 or rezoning. 3, transparent compliance with all codes before approval. If the city approves this as is, we will appeal per Section 28 to 21 and seek an injunction and hold officials accountable for bypassing our rights. We've requested the TIA and are prepared to engage experts and counsel. We'd prefer resolution over litigation, but the city's current course forces our hand. Thank you.
Hi, Rachel Tucker, 3140 Demerit. So to respond to this, even though that is not the point of this vote that we just had, is that we are not saying here that we are not for low-income housing. I'm very for it. I think it's a wonderful thing. It's an important thing, and it very much matters. The issue at hand is whether or not the application is valid and the person who submitted the application is valid in submitting it, and for the access road to be through Demerit, not for the building of it in general. And all we are asking for here as homeowners who purchased homes in areas that were zoned the way they were when we purchased them is that for the zoning to remain the same and for this company to choose a location within Titusville zoning that allows for them to build there. They make money off of low-income housing, whether they do it there or somewhere else. So we are asking that while we appreciate low-income housing, that it is not at the expense of those of us who are trying to also improve our lives in our own way, in our own homes. Also, I've asked if there is any way for you to recall a vote, and I'm pretty sure that Rule 13, I'm told, gives you the option to re-vote, and I ask that you please do that and reconsider the things that you've heard, and to consider Vicki Conklin, our agent. Again, to reiterate, the purpose of hearing us tonight was if you had questions about her application or clarifications, or if you thought maybe she wrote something down incorrectly, that we can all clear it up here, because the point is not for Titusville citizens to get the short end of the stick because of a technicality on an application. It's for you to represent Titusville citizens, not large companies, and to do what's best for those who have applied and who are speaking up for what we feel is best for our community. Thank you.
Is there anyone else who wishes to speak tonight?
So my name's Mary Schwiger, and I live at 2570 Demerit Drive. And I want to remind you that the north end of Demerit Drive is a private road. And so all we have is kind of a flimsy little metal gate that runs across the road. And so I'm wondering, will the developer understand that and respect it? And what about all these people living in Apollo Gardens? Will they be tempted to jump across the fence and come down and use our road, because we do maintain it privately? And so I too would ask you, please, just reconsider your vote and let Vicki finish her presentation.
Good evening. My name is Elizabeth Baker. I live at 1805 Augustine. And you guys are so incredibly lucky. And I want to thank you because you've actually given me quite the education tonight. When we are selecting people as our representatives in cities, we oftentimes don't think about the consequences of that when they put people on boards that they appoint people. And so people that vote, these are the consequences. Here's the consequences. People that sit on boards and absolutely refuse to acknowledge the people. So thank you. I really, really appreciate you driving my point that I've been trying to make forever to people home, in that you have to know who donated to your politicians, and you definitely need to know who they're going to put on their little boards. Have a good evening.
Not seeing anyone else come forward, we will close the part of the petitions and requests. Staff, do you have any updates for us as far as maybe a next meeting or?
No, sir. We do have several applications for the next meeting.
We do have applications for the next meeting. All right. Chairman has nothing to report. City Attorney, do you have anything to report? No report. Any of the members have anything to report? Seeing none, we will call this meeting adjourned. Thank you.